from 2020, or actually no, 2021. So this is actually a very recent summer tax bill. Kind of shows you what a lot of what we'll be talking about for a few things. Just so you can see what's on here. The top of there is the taxable value. That is actually the number used uh, by the city or the local tax assessor to figure out what your actual tax is. So millage is uh, it's a percent basically. It turns into I won't go into the math of it, but basically that's used to you multiply your property taxable value by the millage, you get your tax at the end. So at the bottom right corner there's the total tax. So all those things there underneath the millage in the middle of that tax bill, that's what's being applied to your home. If you go back to the top of this, you'll see too, there's the state equalized value. That is supposed to be approximately half of what the state says is your cash value of your home. I can tell you this is almost always pretty far behind. This number here, 113,000, would imply that the house is worth $226,000. I know this house, and I can tell you that, based on the current market, that house would probably sell for closer to 300,000 rather than 226. So that's just that's actually a good thing for the person who owns the house. You want your taxable value to be low, and you want your state equalized value to be low. Why that matters is because of the first thing we'll talk about is uncapping of your property tax. So what is uncapping? That is anytime there's a transfer of the property, unless it meets certain rules, they reset the taxable value and make it the state equalized value. So you can see in this example that the tax is being based on the 51,000 number. If suddenly your tax bill was based on 113,000, that's more than twice as much. You go back to this page here. That's that $1,600 a month, $1,600 summer tax bill suddenly becomes $3,200, and that's an extra $1,600 a year that you might end up paying. And this isn't very expensive property. A lot of people out there, especially family farms, $500,000, $1 million in property value is pretty typical, pretty easy to get to. If your tax bill suddenly went from $16,000 to $32,000, that's going to make a huge difference. I mean, I've seen, one example I saw was we had a family, a farm where the farm was uncapped, and that resulted in a $8,000 a year extra tax bill. One thing actually, I kind of want to go back to this, and I didn't put a slide in here, and I want to talk about that, is every year you get a new property tax assessment letter for all the real estate you own. That is something you should not ignore. When it comes in the mail, usually around February, you have the chance to appeal any mistakes or corrections or misvaluations at the Board of Review for property taxes in March. If you miss your deadline to appeal, there is no further chance to appeal in most cases. So, if your property tax is doubled or tripled because of something the assessor did or the assessor thought you did, you might not have the chance to get that back. There are, if you did something that was a mistake that causes a change in your property tax bill, that's one thing to remember. You might not have the chance to correct that if you don't catch it soon enough. So don't ignore those property tax assessments that come at the beginning of the year. So like I said, this is uncapping is when they reset that the taxable value goes from, in this example, from 51,000 to 113,000. And it happens with every transfer unless there are certain exemptions that you meet. And these, unfortunately, are not obvious and easy. I listed a few here. So typically, you add your spouse to the deed on your house. There's no uncapping, but not always. If you add, and I guess for the spouses, it's pretty small. Examples would be if your spouse has a business and you're deeding your home into a business, things like that. Usually spouse transfer, adding your spouse to a deed is usually safe, but again, not always. Adding your children or relatives is usually not going to change the property tax bill, but it not always. Same thing, adding your property to a trust. If it's not done correctly, or if it's not the right type of trust, then that can change the property tax bill. If you started a business, big example is you bought a new house and you keep your old place, and you decide you're going to rent out that old house, or you've got a cabin that you've had in the family forever and you want to put it on Airbnb. So you set up an LLC and you think you're doing great. You deed it into the LLC, and suddenly the tax bill goes from, $500 a year to $5,000 a year. I mean, that kind of thing can actually happen. There are ways to do it that are correct. There are ways to do it that are not. Farms are obviously a big one, and there are a lot of rules about transferring farms. There are laws that are supposed to protect the family farm and keep it in the family, but mistakes can basically mean that the family can't afford to keep the farm. So, and then the state of Michigan has a 73-page guideline for transfers. So 73 pages is what they have to tell, and their guidelines really written for the assessors. So it's not something that you're going to pick up yourself and just sort of figure out what you need to do. And I'll tell you too, the assessors don't understand the rules very well either. And I see probably every year 3 or 4 assessors who make a very obvious mistake that if you don't catch it and respond to that, that's going to be a problem. So this is the one most common situation that everybody in Michigan who owns their home knows about. And most of the time, this isn't really an issue. If you buy your home through a title company, they're supposed to take care of the paperwork. So in Michigan, you own your home, you get to deduct or not have to pay the school operating millage. So here's the example in this one. It's but usually around 18 mills, which comes out to about 1.8% of your house value. So if you live in your home and you can claim that as your primary residence, you don't have to pay that 1.8% each year in property taxes. And in our example, that makes a difference of $922 a year. So that's that's a big benefit for a lot of families. And in Michigan, you can claim that on just one property. Married couples in rare circumstances can claim it on 2 properties, but the rules are very strict on that. So not something to mess around with and go, try to do that with your cottage up north, because there are some penalties if it's not correct. Commonly, the way I see this be an issue with principal residence exemption has to do with your kids. A lot of people will have a child living with them, and maybe they'll move, you'll buy a second home, move to an apartment, and your son or daughter stays in the house. They're the ones who are living in there. You technically don't have the right to claim that principal residence exemption anymore. So one mistake I often see is families keep claiming that exemption even though they're not living in the home. The state of Michigan does audits, and if they see something like your driver's license doesn't match the home you're claiming for your principal residence exemption, eventually they'll catch on to that. If you go to a nursing home or assisted living, you're actually allowed to still keep your home as your principal residence. You're still allowed to keep this exemption if you're in a nursing home. There are rules about that. There are limits on what you can do with the home while you're in the facility. But that's one thing to remember. That's something, a question that often comes up with families are, mom went to a nursing home, I'm living in the house right now. What can I do? How does this affect property taxes? So there are, certain circumstances like that where you can keep that exemption even if you're not living in the home. You can live part-time in another state and still claim that exemption. But the rules are that if you're claiming, a home in another state as your primary residence, you're not supposed to also claim the one in Michigan. That's a situation too where, often the state's not going to catch that for a long time, which really just means more back taxes and penalties if the state does catch on to that. So not something to ignore. Other situations I see with this are that people, purchase property from family, friends, neighbors, and they just don't file the right forms. They leave the old owner on the tax bill. Kids inherit property, or mom or dad pass away, the kids living in the house. The house passes them to them directly through the deed, so they don't think anything of it. But mom and dad's name are still in the tax bill, so the state might think that no one's eligible. They'll get a letter from the state saying you owe thousands of dollars in tax penalties. That can be fixed, but again, there are ways that can lead to bigger problems. So usually, in most cases, this isn't going to be an issue for people if you're buying and selling your property through a title company. But a lot of people, especially when they're leaving property to their kids, this is going to be a situation. Make sure I've got the checking my time here. So farm property is a big value in real estate. It can be a big cost in terms of doing this incorrectly. The benefits you get from having farm agricultural property are just like with the principal residence exemption. You don't have to pay that school millage, that 18 mills each year. It's exempt on transfers, uncapping transfers. There's a situation with farms that are kind of confusing to people, and you'll run into assessors who don't know the right rule, and you'll run into title companies who don't know the right rule. This is kind of like one little thing that very few people actually understand is that typically you transfer your house to your children, even if they, let's say they buy the house from you, even it doesn't matter what they pay for it, there's not going to be an uncapping on the property tax bill if it's your child and they're going to be using that as their residence. The thing is, though, that doesn't work for farms. So people think of, the family. A lot of times people think of the family farm as their residence. They treat it like their principal residence. But if the tax bill classifies it as agricultural, you can't just give it to your kids and expect the tax bill to stay the same. Because if it's not classified as residential, that will uncap the property taxes just by adding or deeding it to the kids, or the kids even inheriting the property after you pass. If it's farmland, it's not going to be an exemption from uncapping unless they file what's called an agricultural affidavit exemption. So they can keep the tax bill the same if they promise to keep it as farmland. So even though it might seem like a house, even though it's a house with 80 acres and maybe you're just renting it out to the neighbor farmer, that's if the county or the city treats that as farmland, you have to follow those rules if you want the tax bill to stay the same. So two ways to get this. One is if the local assessor has classified that as agriculture. Hold on, let me see if anybody's lost sound here. I've got a note that somebody lost their sound.
I hear you, Bill. Okay, now I don't know. I'm sorry, I don't know what happened. Let me reach out to Bill.
Hey, Chris. Okay, so I'm back. I don't know if everybody can hear me, but
We can hear
my-
you and we
okay.
never lost your sound.
Oh, because my Zoom just restarted and it says, no, wait, now it says I'm a participant rather than a host.
I can make you,
So are you able to see what the
I can only
screen?
see you.
Okay, so I'm not
Just a
sure what
second.
happened here. Okay. Okay, so now I'm the host. Okay, I'll
If
start
you can
sharing
share
here.
your screen again.
Yeah.
Sorry, everyone, for the technical difficulties.
Yeah, so
Not sure what happened. There you go. You're all set.
all right, good. All right. Well, yeah, I'm glad somebody noted that they were having somebody else lost some sound problems. So, not sure what happened here. If it was my computer, but I just saw that Zoom reconnected on my end. But kind of backtrack a little bit on the farm property. So there are two ways to get this exemption on farmland. One is if your property is classified as farmland by the local assessor. The other one is that you can ask to have your property treated as agricultural, even if it's already currently zoned residential, by saying that there's showing that there's more than half the land is being used for farming. So you can actually get this benefit too. So the reason why people might sometimes want their property treated as agricultural is if you're going to sell it to a farmer or sell it to another person who wants to keep using the land the same way you've been. Even if you've got just a hobby farm with some goats or something, you can basically sell that property to a new buyer, a stranger, and they can still keep the same tax rate you had, which is a huge benefit for people. So that's why there's benefits for the agricultural exemption. I mean, the whole point of it is really to try to keep farms as farms. Unfortunately, they put some restrictions in there that even people trying to keep it as a farm often fall into these holes, these restrictions. The biggest one is that if there's a house on the farm and it's part of that farmland, whoever's living in that house has to either be the owner or someone working on the farm. So this is the most common example I see where there's a problem is, mom or dad have multiple pieces, there's a farm, they got multiple properties, they have multiple farmhouses because they've bought the neighbor's farm over the years. If they just rent that house out to a random person, that entire parcel that house is on could be uncapped. So that could be a huge, huge penalty. There are ways to avoid that. If you do want to rent it out to somebody who's not a farm worker, you can split off that house as a separate parcel, and they'll uncap that one piece. Or you can just make sure whoever's living in the house is either a worker or an owner. But that's a big one. The other issue is this: if you do lose the ag exemption, if you've bought the property and you've filed this affidavit saying that you're going to keep it as a farm, and then you convert it to something else that's not a farm, you start developing it, there's 7 years of back taxes, and it's 7 years taxed as if it was never a farm in the first place. So obviously, if it's a commercial or big real estate development, that might be worth the cost, but that's just something that is a big penalty for people who unintentionally make the mistake. And like I said, going to a nursing home is the easiest way this gets lost. So because mom or dad, aren't living in the house, and the kids want to figure out what to do with this empty house. And even if it's a child or a niece or a nephew living in the house, if they're not involved with the farm, that technically doesn't qualify. So we see that actually comes up, and that's kind of where that $8,000 a year tax bill situation came up. Was the family had someone living on the farm that wasn't working on the farm, and they knew they weren't, but thought they could get away with it, and that whole parcel got uncapped. Next page. So forest property is really a lot like farms. In terms of the benefits, in terms of, you don't, it's just like the principal resident exemption, you're not paying that school tax. There's no uncapping on the transfer if it's kept in that forestry program. The way it works is you can, go to the State Department of Agriculture, talk to their qualified forestry program director or the local, county ag exchange office in your county. If your land is at least 20 acres and if it's 20 acres, it needs to be 80%, forest land. If it's over 40 acres, it just needs to be half forest. So big example of where this can come into play is if you got up that hunting property up north and it's mostly forest and maybe you are, letting somebody come in and cut trees once in a while. If you actually bother, if you go through the trouble of getting into this qualified forest program, it can be worth the expense. I mean, there is a fee, an annual fee for this. There's an annual filing. So if you can claim it as your residence, if it's your home, it's not going to be a benefit. But if it's that, hunting land up north or that vacation property up north and it's more than 20 acres, you can save, saving that school millage, like I said, an example with the house, that's $1,000 a year. If you've got 80 or 100 acres of hunting land up north, that could be a lot more per year that you could save just by getting it into the forestry program. And really all it involves is they'll have a certified forester go through the property. There's a program that you have to sort of enroll in and keep up with. But, and I rarely see people actually doing this. And there really could be, thousands of dollars a year they could be saving on that, hunting property, cabin property up north. But like I said, if you're living there, it's not going to be a benefit for you because there is a fee every year so if you're able to claim the principal resident exemption, you can save more that way. So this is another one where everybody probably at some point, if you've bought a house or sold a house, this has become a situation. So basically it's called transfer tax, but it's basically a sales tax on your home. It's a few percent. It's not huge, but obviously on the value of a house, that can be a pretty big number, in thousands of dollars on a sale. And any sale, if there's money or value that was exchanged, there's going to be a tax. If you give the property to someone or someone, inherits it under certain rules, there's no tax on that. So kids who inherit property aren't going to be taxed on the value of the transfer. But if you sell the property, and the other one I see that people try to get away with is they'll sell a piece of property to their neighbor, do the deed work themselves and claim that there was no money exchanged, and they basically just committed tax fraud. So that's not something you want to do. I mean, if you actually get a benefit, if someone, if you sell some property to someone and they're taking over the mortgage on the property or they're taking over the land, there's a benefit that you received. So there's a tax that gets applied based on that, what was paid. All or part of that tax can be reduced if there's a transfer between spouses or to children or grandchildren. A big note, obviously, is siblings, aunts, and uncles don't count, and this happens a lot too with, a group of kids inherit a piece of property from mom and dad, and they want to sell it off to the one brother who wants to buy them out. There's going to be an additional tax on top of whatever they're paying for that transfer, because siblings don't count. Same thing, a lot of times people want to include a spouse, and this is actually something I was going to bring up with the farmland too, and with uncapping. There are rules for the uncapping on transfers to children. Spouses of children aren't included, and this is a big one I see a lot that involves transfer tax. It involves uncapping. Mom and dad put the son's name on the farm, or they sell the farm to the son, and on the deed they put the son's wife on the deed as well, because they think, well, he's going to want his wife on the property, so we'll just deed it directly to the son and wife. That's a big mistake, because now half of the value of that land just went to somebody who's not related to them. The silly trick is, mom and dad can deed the property to son can deed the property to himself and his wife, and there's no tax. Because the rules, that's the kind of things that aren't logical, don't make sense, that if you're not aware of the rules, that's where people can hurt themselves. So that's a common one. So on transfers, basically, selling property to somebody, there's going to be a tax. By default, the person selling the property has to pay the tax unless there's some deal that the buyer is going to pay the tax. And usually if you're selling stuff through a title company, this is all taken care of at the title company. But I see probably at least once or twice a month we're dealing with property that at some point in the past somebody's bought or sold privately without a title company being involved. So that's where mistakes on taxes like this happen. And what will happen is, if the register of deeds sees that your deed has a value on there for money, they're not going to record it until somebody pays the tax. Another example where this can be a surprise issue is land contracts, because that sales tax actually isn't paid until the person's paid off the land contract at the very end. So 10 years later, you as the seller, or somebody as the seller, is deeding that property over to the buyer. They might have gotten all the money years ago. They might have bought it from somebody else. They might not have even gotten very much money. But if the total value of the land contract that was originally signed said $100,000, that's what the tax is going to be. So, and that can be, and if people have done these deeds themselves and done the land contracts themselves, it's going to be the seller who has to pay for that, which people might not expect. So this is another one that is rare in the big picture, but we still see every year. We've got multiple clients who qualify for this. Basically, if you're 100% disabled veteran, or you receive housing assistance as a disabled veteran, or you've been labeled, the Department of Veteran Affairs says that you're unemployable due to a military service related disability, you don't have to pay property tax on your home in Michigan. So it's just on your house. You, as the disabled veteran, have to be on the deed in some way, or it can be in your trust. The only other person that can be involved as far as owning the property is your spouse. So, and if you pass, and if the veteran passes away, their spouse gets to claim this exemption as long as they stay unmarried. So it's 100% tax, free property tax, which a typical house is going to be several $1,000s a year. And this is someone where you have to file a form every year to keep this up. So, because I guess technically it's possible that someone might no longer be disabled, or that, if they've sold the house or added someone else to the house, they might not qualify for it. And this is one where it's easy. Again, mistakes can happen. People go down to the road to their church buddy who's a lawyer, does a simple trust for them. They put the house in the trust. Suddenly now they've done something incorrectly and they lose that veteran's exemption. A simple, $500 trust done by your friend can lead to thousands of dollars in tax bills tax that you have to pay extra. Nice thing about the disabled veterans exemption is you can always fix that. If you've lost it for 1 year because of something you did, you can correct it and then apply for it again the next year. And as long as you fixed everything, you can still qualify. This is one where probably even less common, but there are, especially with a lot of places in Michigan, retired seniors living on some property that living off of Social Security, or families living, and the numbers go up. So basically, the larger the family living in the house, the less or the more they can make and still qualify for this exemption. So basically, what it is, there's a rule in Michigan that says if the family in the home makes below a certain dollar amount, and it's usually based on the federal poverty guidelines. For example, here, a family of 4 that makes less than 26,500 can get their property tax exempt, so no tax bill on their home. And local counties, local assessors actually are allowed to raise that dollar amount. So they could say, well, we'll let families making 50,000 a year or 60,000 a year claim that exemption. So just because, the poverty guidelines look low, and just because you might think, someone might think they don't qualify, it's actually possible that based on where you live, you might be able to qualify to have your property tax bill written off, even though you don't think of yourself as being, impoverished. But it's a benefit that the local counties and assessors and cities can make that isn't something that's going to be out there publicized. But definitely, if someone is having a challenge paying property tax bills, it's worth looking into. And again, that's an annual filing on that one. And they'll also look at, all your available resources to pay your bills. So it's not just a simple form. So this is another one that will affect everybody at some point. Because if you haven't inherited property, you're probably going to own your home when you pass away, and your kids are going to end up with the property. And it's pretty simple. I mean, the simple rule is you inherit property, or someone who inherits property and sells it right away, there's no income tax. It's a tax-free sale. It could be $2 million in real estate. And it might have started out as, a $100,000 piece of real estate, and you've got $900,000 in gains. You don't have to pay tax on that gain. I mean, if you sold the house while you're alive, there's tax that you'd pay potentially. We'll talk about that in the next slide. And this applies to all property, not just real estate, but actually stock, any other type of investment, any other type of asset. Basically what it means is, it's normally when you sell something, you pay income tax based on the difference of what you paid for it versus what you sell for it. Someone inherits property, that starting number, the low number, gets reset to whatever the current value is at the time of death. So that's why it's basically what we say is you inherit the property and sell it right away. You're given a 6-month window to do that. So even if the property is going up in value really quickly, or it's going down in value, you can, as long as it's sold within 6 months, it can be tax-free to the kids. That's kind of the big one. I put down there the average home sale. So the average home sale in the U.S. in 2020 was about $69,000 in profit. And maybe I'm doing the math right here, I can't remember, but basically, and based on the average income for the person in America, because the capital gains tax rate's based on your income, they say a person would save $10,000, a little over $10,000, by getting this step up in basis. One thing you might have heard in the news, there's talk about changing the tax rules and taking this away, getting rid of this step up for inheritance. And one way to really look at it is it's going to be an additional $10,000 tax bill, for the average person who inherits property. That's really what it is. This is $10,000 in taxes that the government's not collecting, that if they got rid of this rule, they will collect. So this is a huge benefit for people who inherit property. It's also a mistake that sometimes people make where, if you put your kid's name on the deed while you're alive, you give, you put the kid's name on your property, you give them stuff while you're alive. It sounds, personal property is different. You give them your family rocking chair, yeah, but you put the kid's name on the house, and suddenly now you've just given them a tax bill later on down the road when they sell it. So keeping a trust, passing it to the kids that way, it's tax savings for the kids. And so this is the example for if you're selling your own home, and this is one too the title companies and realtors take care of, and generally people don't really even pay attention to this. But the short answer is you sell your home, you don't pay income tax on it, even if it's gone up in value, $100,000. Like I said, the average home sale last year in the U.S., the average gain was $69,000. So that's tax free to you if you sell your own home. The longer answer is, it's limited to $500,000 in gains. You have to have used it as your primary home for 2 of the last 5 years, and you only get to use this exemption once every 2 years. So, not many people are selling their house more often than once every 2 years, but the kind of example of this is, you own 2 pieces of property. You have a house here in Michigan, you've got a summer place in Florida. You're selling one of those. If the Michigan property is a very small, inexpensive condo, and the Florida property is on the ocean, and you might sell both of them sometime in the next couple of years, it would be a mistake to take this exclusion on the sale of the cheaper property, because if you sell the expensive property the next year, you can't use this. So that can be a big tax mistake. So planning, selling property, and thinking about this matters. This is actually I've seen a lot of small-time home builders actually use this. By what they'll do is they'll build a house, they'll have a home development, they'll go and live in the model home, so they can claim that as their primary residence. And so when they sell it eventually, and then in their case, they've built it, so their capital gain is probably going to be even greater than a typical person. They can exclude that income on the sale for that home. So that's one of the things that a person can legally do, and that's one of the examples of you can pay less tax by following the rules, but you can pay more tax if you don't know the rules. All right. So that was the 9 secrets. I've got the bonus secret here. Is the bonus secret is none of this matters if you lose the home. And long-term care is the number one way people lose their home. Mom or dad gets sick. The kids aren't able to take care of them. As much as people say they're never going to let their mom or dad go to a nursing home. One example is with Alzheimer's or a lot of other dementia, where they're physically fit, but they're still getting in the car to drive to Sunday church, but they're doing it on a Friday at 3 a.m. because that's kind of situation that happens where people aren't safe in the home, and so they end up in a home, or it was just mom and dad at home alone. The kids have moved to California, and no one's around, and that's where they could have done all the savings in the world to save the home and pass on the cottage to the kids. This isn't going to do anything if they lose the home. And so, big examples is if you have to sell the house to pay the nursing home bills, if you don't do anything to protect the home after you die and it just goes through probate court, the home can be lost to debt collectors, to the state of Michigan to collect for Medicaid, or the kids do inherit the property, but they're in the middle of a messy divorce. They're in the middle of their small business failed. They had a restaurant last year that got hit by shutdowns, and now they're filing for bankruptcy. Giving them a home that ends up going to bankruptcy doesn't help anybody. So all that can be avoided. You can save the tax and you can save the home with proper planning. So that's one thing to say is put your home in a protection trust first. That's the first step to saving the home and saving these taxes. But that's really kind of like none of this matters if it's not saved in the first place. So at this point, I kind of open it up for questions. I do see I've got a question here. I know Chris has been collecting some, but I've got one here that came through as well. So as far as agricultural property, there's not really a requirement on the size of the property.
So
like
it's just better to ask the question.
Yeah.
I mean, it's better to, so the question is agricultural property.
Oh yeah, sorry. I should have yes. So the question is, the question is with agricultural property, if there's income from agricultural property, is there a minimum acreage size? As long as there's income, and no, there isn't. So with the farm, you could have your 10-acre hobby farm, and if it meets the if more than half of it's being used as farm, or if it's been classified as agricultural by the local township, you still can claim that agricultural exemption. Doesn't matter how small it is. I actually know we've got a client who they have a lavender farm. It's not a big piece of property, but that it's a business, and it doesn't take a lot of acres to run the business. So the big example too is people with goats and cheese and that kind of thing. So forest land has to be at least 20 acres. Farmland, there's not a minimum acreage size. All right, so any other?
I have another question.
Yes.
What happens if the kids live in the house after I pass, or if I end up in a nursing home?
So the big situation there has to do with that principal residence exemption, because to claim that exemption, you need to be living in the home. So there's the one rule I think I talked about a little bit was with a nursing home. If you are in a nursing home and the property is, what the rule says is you have to be able to move back to the home, which means no, you can't have leased it out to somebody. The kids can live there as either as a caretaker or just to just to keep the place occupied, and still claim that principal. You can still claim that principal residence exemption. So that's a big deal, because with a vacant home, insurance rates go up. Vacant homes, empty houses burn down is basically what insurance companies say. So if you can show that there's a kid living in the house or a caretaker, that's going to save on the insurance bill. Plus, you could still keep that property exemption. Another big example is kids inheriting the property from the parents, or where I see this go wrong is the son or daughter was living with mom and dad. Mom and dad's name was on the deed. They pass away. Nobody does anything. The child keeps living there. They never bother going to probate court. Everything is still in mom and dad's name. They're not qualified to keep, and if the assessor's not going to always catch this for you. Places like Grand Rapids, the city of Grand Rapids, they've got the computer systems. They're tied into the death records and Social Security. They're going to know if someone's passed away, and they're going to send you a letter very quickly asking who's living in the house, who's claiming that exemption. A lot of places in Michigan, the kids could be living in the house for decades, for years, and the assessors never catch this. I mean, I have a sort of a funny story. So with my family farm, my parents' farm, my dad was, the farm was deeded to my dad in 1972 from his mother. The funny thing is, the attorney that they hired in 1972 recorded the deed in the wrong county. So as far as Muskegon County was concerned, that farm was in her name since 1972, and she died in 1978. And we didn't find this out until 2010. So 40 years. Technically, as far as the records were concerned, Muskegon County should have been, charging him a different property tax rate, because there's never any record that he actually owned the property. So, fortunately, I actually was, I was sort of taking care of the stuff for my parents, and I saw, oh, this attorney's address, their office is in Grand Haven. Maybe Ottawa County is where he filed it. And so we were able to find the actual recorded deed in Ottawa County, and Muskegon County accepted a certified copy from Ottawa County to record in Muskegon. And So that, and if it wasn't for that, and that's sort of another example of, we don't worry about keeping those deeds. The deed gets recorded. People don't think about it. And that's the case where if we had no idea where the deed was, we also had the original deed still. But if we didn't know where it was and we couldn't prove it, and we didn't have a copy of it, that could have been or somebody just forgot to record it and lost the original, which happens too. That could have been a nightmare. So that's a real common one, was kids living in the house after the parents pass away, and if things aren't, and they technically don't qualify to keep that exemption, but assessors they're gonna still keep getting the exemption unless the assessor knows it. So I have another question about the farmland, sort of a clarification. So looking to qualify for the ag exemption, does the income have to come from at least 50% land usage, or you can have the income from 10% land usage? So it's a little, it's not as straightforward rule for farmland. So if you're using more than half of it for farming and you're not really getting any income from it because it's not really making money, you can still get the ag exemption. If you're filing a tax return as a farm based on income from 10% of the land, it is possible, it could be possible to get that ag exemption. But if the property, and another thing too is, a lot of times the assessor, the local township's already classified your property as agricultural. You don't even need to worry about this. The whole thing about 50% and income producing really comes in if you're trying to convert residential property to agricultural property. But if it's already classified as agricultural, and so that's a common thing, is it's not like it's not a hard and fast rule. Part of it is, what you can show the assessor. They make the decision. They still have to prove it. Even if, you could meet what you think is the requirements, but they make the decision on what they want to classify it as. You're just asking them to classify it. Okay. All right. So we have
I have one more question. What happened, excuse me, does the name on the tax bill really matter?
Okay, that's a good one. Because that actually, it matters in terms of where the tax bill goes. The tax bill shows, the tax bill shows who the assessor thinks is claiming the principal residence exemption, but that doesn't necessarily say who owns the property. So a lot of cases are, a couple examples are, people put, we put the property in the trust, the assessor doesn't bother updating the tax bill, so the tax bill still has your name on it. And we get people all the time thinking like, oh, the property's not in my trust, it's not been deeded. But that's just because the assessor doesn't always update their tax statements. Same thing too is, the kids who are heirs to property, inherit property, and the property based on the deed and the trust says they get to live in the house, so they're entitled to the tax exemption, but the tax bill might still have mom and dad's name on it. So that doesn't really prevent them from getting that tax exemption. So the tax bill and the actual ownership aren't really related. All right, so I see another question. See, we want to sell and deed our second house to our child and their spouse based on the current mortgage balance, not the much larger current value of the property. Will we need to pay tax on this? Is this considered a gift tax exemption? So if there's a mortgage on the property, there's a couple of different parts to this, answers to this question. First part is, if there's a mortgage on the property and you're deeding it to someone and they're going to be paying the mortgage, that is a sale to them for the value of the mortgage. But if it's to a child, you can, that sales tax, the transfer tax, you can be exempt from. The other issue though with doing that is, if the actual value of the house is a lot higher than the mortgage, then you've got to worry about Medicaid, because Medicaid has rules that say if you sell property for less than it's actually worth, that that could prevent you or disqualify you or be a penalty for you for 5 years for Medicaid. So that's where Medicaid comes in as well for that. So, but yeah, if you're selling property to someone for less than it's actually worth, the transfer tax is just based on what you actually receive, not on what it's actually worth. And there's not a gift to, I mean, there is a gift to the kids. So if the difference is more than 15,000, there's a form that you're supposed to file with the IRS. And this is kind of a little digression. Maybe I should explain the whole gift tax thing that people always ask about with the IRS and $15,000 a year. That's a reporting requirement. The rule is there's a lifetime gift limit. And right now it's $11 million per person. So if you go over that limit during your lifetime and give away that much stuff, you have to pay a tax. And if you give away more than 15,000 a year, you have to report that to the IRS. So that's why people want to keep it below 15,000, because they don't want to report it. Because if you don't have to report it, it also doesn't get added on to that total amount. But there's no real penalty. There's no harm to give away more than 15,000 and report it to the IRS, because most people aren't likely to hit that $11 million number anyway. So it doesn't mean there's a tax, but it just means there's more reporting required. Let's see, so another question here. I inherited my family home. All the bills come in my name except the water bill. Will this automatically switch, or must I notify the city? So it won't necessarily automatically switch. And this is a common situation we see with spouses too. Let's say the utility bills were all in the husband's name. They're not going to automatically switch over to the wife, even though she's on the deed and has been on the deed. And we see cases where utilities get shut off because usually it's not going to be water and heat, but things like the phone or cable TV have to be switched over. So that's, you're going to save hassle later on if you make sure that both people's names are on those utilities. But yeah, there's not going to be an automatic transfer, and you will want to try to get your name on the bills as soon as possible. So they have a question about their attorney recommended not registering their home transfer to the living trust until after either of you die. There's problems. I guess it depends partly on what type of trust it is. It also, if it's the basic, typical, revocable living trust, that's kind of a complicated question to answer, because it really depends on what's the situation with you. Is there a reason why, if you're concerned about possibly needing nursing care in the future, or you've got health issues, or you're on Medicaid now? There are certain cases where it's usually only involving Medicaid, where you might not want to record the deed or register the deed, but usually the risk is, if it's a deed that gets lost, that's the problem with not recording these or registering these. Or if it turns out that what you would have done would have been a tax, and then when you do it later on, the state decides to say, well, you should have paid the tax back to when you actually signed the deed, not till when it's actually recorded. So that's something I wouldn't just be able to really say yes or no, that's a good idea, without knowing all the facts in that one. But so that's
Would that be a good situation for them to come in and review their trust and
definitely,
get all their questions
and
answered?
if you've got another attorney who did this and told you something, we can review it. So we do free, no cost review meetings, trust meetings, estate planning meetings. So if you don't have anything set up, we don't charge for you to come in and talk to an attorney. If you want to go to a workshop, we have free workshops. And even if you have, if you've got a whole plan done by someone else, even if it was just done a year ago, there's no cost to have us, to come in and have us look it over and review it. And that, if you want to have a second opinion, basically, we'll be happy to give you one. And that's definitely, if any other questions that you have, or anything more complicated than what we talked about here, or if I didn't answer a question, It's always a free phone call. It's always a free meeting. We can definitely answer any questions you have and get you taken care of.